This is an appeal in the matter of Vince and Tice.
Please, your lordships, I appear on behalf of Dale Vince, the appellant in
Yes.
this matter, with Mr. Ben Hamer, and Mr. David Price of King's Counsel and Mr. Richard Munden appear on behalf of Richard
Yes.
Tice, MP, the respondent. My lords, if I could proceed by first of all setting out some of the background to this case, because of the way the respondent's case is advanced depends to some degree in understanding what happened at the first instance hearing.
Yes.
The chronology is broadly, if I could take you to the supplementary bundle, to tab 4, page 1818.
Tab 4.
Tab 4.
Yeah.
This was an article published by the publisher of the Guido Fawkes website, Mr. Paul Staines. And as you can see, and as was later found by Mr. Justice Pepperell in this claim, this defames Mr. Dale Vince, who you can see pictured there.
Yeah.
Not only have you got the print on the page, but you've got a short video extract playing as the reader of the tweet watches the page. And that's an interview between Mr. Stig Abel and Mr. Dale Vince on Times Radio. And I should say it's not necessary for your determination to today, but it is part of the claimant's general case that misrepresents him by selectively quoting him. You can ignore the part at the bottom of the page which begins with the word update.
Yeah.
That shouldn't be there, that was added at a later date.
Yes.
Now, at tab 3, page 17, you can see a transcript of the interchange between Mr. Abel and Mr. Vince.
Yes.
And a video's been supplied to you of that recording, so that you can view it in the flesh, as it were.
Yes, and I got to the video through the supplementary bundle because the memory stick had a password required, and I didn't know what it
I'm
was.
so sorry about that.
I think we have
you've got it.
memory sticks without a password on them, which we can.
Oh, is that right? Well, the one I got in my bundle required a password, and I had no idea what it was,
Okay.
but I have seen it.
I'm grateful for that.
There was a hyperlink on the electronics.
Didn't have a password. So
There was a hyperlink on the electronic bundle. And I got to it
Yes.
through that.
Oh.
Yeah. And then you'll see at tab 1, page 3 of supplementary bundle, you'll see a tweet by Richard Tice MP, that's the
Yes.
defendant to this claim, where he says, so major Labour donor is pro the murderous anti-Semitic Hamas. Then below that, there's a tweet by Guido Fawkes, which says, while we're on the subject of extremist donors and returning their donations, you've got the headline, multi-million-pound donors to Labour Party says Hamas are free fighters there. You've got the same video, the same 16-second extract plays. And if you click on the Guido Fawkes tweet, you're taken to a hyperlink back to where we started, the Guido
Yes.
Fawkes article.
Just for my edification, the pleading refers to the Tice tweet. Does that include the Guido Fawkes
Yes.
material?
Yes, it
It
does.
wasn't entirely clear to me whether you meant just the
Oh, I
words
apologise
added
for
by
that.
Mr. Tice or the whole thing.
The whole thing.
Whole thing.
And so Guido Fawkes, or Paul Staines, the publisher of Guido Fawkes, was sued separately. And then Mr. Tice was sued in his own claim. And if I could take you actually...
Mr. Staines was sued in respect of the Guido
Just the
Fawkes
article.
articles,
Just the
not the
article.
tweet.
No. And the particulars of claim concerning the matter before us today, you'll find in the core bundle at tab 12,
Yeah.
that's page 114. And if I take you to, following the initial averments, to page 115 of the bundle, and you see at the bottom of the page there, words complained of. At 15:47 on the 13th of March, the defendant quote tweeted the Guido Fawkes tweet, the GF tweet, the Guido Fawkes tweet, to which he added the statement, so major Labour donor is pro the murderous anti-Semitic Hamas. The full tweet published by the defendant appeared as follows, and then you'll see it over the page, and that's the Richard Tice words followed by the Guido Fawkes words. And then just below that, paragraph 11 says, those readers of the defendant's tweet who followed the links to the Guido Fawkes article also read the following words in the article. And that sets out the wording of the Guido Fawkes article. And then you'll see at paragraph 12, there's reference to two categories of publishees. The first category, which inevitably will be the largest category, is those people who just looked at the defendant's tweet, that's the defendant's comment plus the Guido Fawkes tweet, and just then scrolled on to read something else. Or those who read the defendant's tweet and followed the hyperlink, and also therefore read the Guido Fawkes article. 12.2.1 there, you'll see the number of people who read the tweet. And then following paragraph 12.2.2, it says the Guido Fawkes article referred to the claimant by his name. Therefore, by following the link to the Guido Fawkes article and reading it, where a reader had not already identified the claimant, merely from reading the defendant's tweet, he or she could do so by reading the Guido Fawkes article. Publication of both categories of reader is complained of. In each case, the meaning, the defamatory meaning of the claimant is the same. And then paragraph 14, that message is reinforced, where it says the defendant's tweet in isolation and the defendant's tweet read in conjunction with the Guido Fawkes article defame the claimant in the following meanings. The judge largely rejected meanings A and B, but the meaning he did find, which I'll come to shortly, is perhaps a more pithy and straightforward expression of the meaning set out there at paragraph C, reference to supporting Hamas and describing it as an anti-Semitic prescribed terrorist organisation which murders Jews because they are Jews. So claims were issued against Mr. Staines for the Guido Fawkes article and Mr. Tice for the publications I've just taken you to. As has become standard practice in libel claims, the parties wanted trials of preliminary issues to determine meaning, whether the words were defamatory and whether they were opinion or not. Now, you'll see there, the way the case is framed on behalf of the claimant is that there are two sets of publishees, those who just read the defendant's tweet and those who read the defendant's tweet and the Guido Fawkes article. Mr. Tice challenged that and stated, I think for reasons we don't need to go into too deeply today, that the only group of readers relevant to the claim were those who read the defendant's tweet and didn't follow through and also read the Guido Fawkes article. Now that raised an issue of fact because you needed to know which words were going to be determined as to what they meant at the meaning hearing. Was it going to be the defendant's tweet by itself or the defendant's tweet plus the Guido Fawkes article? The practical solution proposed by the claimant was that Mr. Justice Pepperell should just determine what both publications meant, what the defendant's tweet meant by itself, and what it meant read in conjunction with the Guido Fawkes article. And then the trial judge could determine whether in fact the defendant was right to say that in fact there'd only been one group of publishees, not two. Because on the defendant's case, the reasonable reader wouldn't have read the Guido Fawkes article. Now this matter came before
Can I just
Master
ask this,
Doug.
why does it matter, since you plead in paragraph 13 that in each case the meaning is the same?
Well, first of all, the judge was free to decide that the meanings were in fact different. But secondly, it's important for us to maintain the case concerning the Guido Fawkes article, because whilst Mr. Vince is visible in the video on the tweet, and people who knew him would recognise him, he's named in the Guido Fawkes article.
I thought it was conceded that there was sufficient reference to him.
Well, it's under defamation law, one's got to be very wary of Section 1. One's got to prove serious harm to reputation. And it would be a normal submission to say where someone is actually named, that causes more harm to their reputation. But very much it's it's the claimant's case and the defendant's case that both publications meant the same. But it was also the claimant's case that the words used in the Guido Fawkes article reinforced the allegations, reinforced the meaning, because there are particular words in the article to the effect that Mr. Tice was reported to have said that Hamas had a right to defend itself, which doesn't add a discrete meaning, but we said reinforced the meaning that we advanced before Mr. Justice Pepperell. So it was relevant for that purpose. Master Dagnall left it to the judge, Mr. Justice Pepperell, to decide whether there were one or two publications or just to decide what they both meant, and leaving that issue to the trial judge. He left the issue to the trial judge and determining the meaning of each publication. That's defendant's tweet and defendant's tweet plus the Guido Fawkes article. Now, at that hearing, the claim against Mr. Staines was also heard, because clearly, given that the Guido Fawkes article was part and parcel of our claim against Mr. Tice, that made sense. And the hearing took place in a very wrapped up manner. At the application of Mr. Tice and Mr. Staines, it was wrapped up, and I had to make all of my submissions in one go about both claims. So my submissions about the meaning of the Guido Fawkes article was mixed up, and properly mixed up, because they were connected with my submissions about the meaning of the defendant's tweet by itself. Now, the nature of a trial of a preliminary issue in a libel claim is that each party sets out their position on what the single meaning is. They don't set out various permutations of what the meaning might or might not be. And as you might expect, on the claimant side of court, they go for a high meaning and say it's an allegation of fact. On the defendant side of the court, they generally go for a low meaning and say, well, it's all opinion, because that makes it easier to defend. But the judge has complete freedom to decide the meaning that he wants to impose, and he's not bound by the meaning pleaded by the claimant or the defendant, but broadly, he's bound by the parameters set by them, the ceiling and the floor, if you like, of the meanings. And nothing arises on that point here. Now, the judge found that the defendant's tweet and the defense tweet read with the article bore the same meaning. And that is that the claimant supports the murderous anti-Semitic terrorist organisation Hamas. And he found that was a statement of opinion, which is clearly the main reason why we're here today. And the basis of that opinion was what was set out in the Guido Fawkes tweet. That's the tweet I took you to, where it says, well, what about this other extremist donor, and claims that Mr. Tice said that Hamas are freedom fighters. Now, turning to what the Guido Fawkes article meant, if I could take you to the judgment, which you'll find at tab 8 of the core bundle.
Yeah.
And if I could take you to
Paragraph 48.
I want to take you actually just before there to paragraph 30. This is important for setting out the basis on which the judge reached his conclusions. Now, what the judge did at paragraph 30 is find that the reader who read something about Hamas read it with common knowledge. That is, the readers assumed to have known something about Hamas. So you'll see at page 87 of the bundle, paragraph 30 of the judgment at the bottom. It's page 87, paragraph 30. Mr. Justice Pepperell says, sadly, there are many terrorist outrages around the world that quickly fade from the collective consciousness. Even though on foreign soil, the events of 7th October 2023 were, however, in that rare category of events that were so brutal and committed on such a scale, they attracted wall-to-wall coverage. And then you've got another sentence which really talks about how notorious these activities were. And then if you just go up 5 lines from the bottom, the sentence beginning accordingly. Accordingly, at the time of publication in this case, I find the fact that Hamas is a terrorist organisation and that it was responsible for the murder, rape and kidnap of Israeli citizens in October 2023 or matters of common knowledge that can properly be taken into account when identifying the natural and ordinary meaning of these publications. And then, as you say, he found the meaning itself at paragraph 48. Which you'll find at page 92 of the core bundle. Now, just before going into those meanings, there's perhaps a mystery as to the words that are underlined. We deduce the words underlined are in fact those words that are found to be common knowledge, but the judge just hasn't spelt that out in the judgment. Interestingly, in the Bailey judgment on a similar matter, where he imputed common knowledge as well, he did underline the common knowledge parts of his meaning and stated elsewhere they were common knowledge. So in case you were wondering, that's our deduction of why those underlinings are there.
So if underlined equals common knowledge.
Yes. Now, the first meaning doesn't really concern this claim one way or the other. It's that at 48.1, because it's really directed at the Labour Party. The Labour Party has been hypocritical in calling for the Conservatives to return donations when it has not returned donations made by Mr. Dale Vince. Then the two following meanings really defame Mr. Vince, what are concerned in this claim. Mr. Vince has said of the terrorist organisation Hamas that one man's terrorist is another man's freedom fighter. Then lastly, Mr. Vince believes and said on Times Radio that the terrorist organisation Hamas that carried out mass murder, kidnapping and rape in October 2023 are freedom fighters who should have the right to defend themselves. Now, Mr. Justice Pepperell found that these allegations were not only defamatory, but allegations of fact directed at Mr. Vince. Now, at paragraph 80 of his judgment.
And that he says that in paragraph 58.
Oh, yes, pardon me, I can give you the reference. 56 to 58, he sets out they are statements of fact. But turning to paragraph 80 of his judgment, this is where he decides, where he's speaking about should he determine whether there are one or two publications, or just decide the meaning of both. He says further, no one's argued that the meaning of Mr. Tice's tweet is affected by whether the hypothetical reader clicked on the Guido Fawkes tweet. I've considered the meaning of Mr. Tice's tweet both on the basis of considering his tweet together with the displayed Guido Fawkes tweet and the video, and such material together with the hyperlinked Guido Fawkes article. Therefore, he's making it clear that his judgment is that he has considered the contents of the Guido Fawkes article, and that can only be relevant in regard to what we call in the skeleton the second statement, that is the publication of the defendant's tweet with the article. Then he says, like counsel, I conclude that consideration of the additional hyperlink material does not affect the meaning of Mr. Tice's tweet. Now that is correct, that's the submission of both parties, that the meanings are the same, but certainly the judge's hands weren't tied. He could have found different meanings if he'd wanted to. And then he says, accordingly, it's not necessary to decide the issues to whether there are one or two publications in order to determine the meaning. And there is no prejudice to the defendant by reaching that conclusion because the issue remains open for the trial judge, or if the defendant wants to make another application beforehand, for that issue to be determined. Now, if I can move on to ground one of the appellant's grounds of appeal, and that is simply that whether one looks at the defendant's tweet by itself or the defendant's tweet in conjunction with the Guido Fawkes article, it amounts to a statement of fact, not a statement of opinion. And we believe it to be uncontroversial that the test on appeal is that provided by the House of the Supreme Court in Stocker, which I've quoted at paragraph 23 of my skeleton argument. And essentially it boils down to the judge must be plainly wrong. That is paragraph 23 of the claimant's skeleton argument. which you'll find at page 32 of the bundle, tab 4, the bottom page, paragraph 23. I could just ask you to read that. You can phrase it in various ways, but I'm just going to paraphrase it as being plainly wrong. Now, it's proper law, and the judge followed this principle because he quotes the case of Chiropractor Association and Singh, that one determines whether a statement is opinion or not by reading the whole of the statement. But of course, he has to determine an actual meaning to synthesize the statement, to really enable the claim to proceed successfully so everyone knows what they're arguing about. Now this brings to the forefront of our argument the consideration of what actually constitutes opinion for the purpose of the honest opinion defence. And staying by skeleton argument, I've set out the principles from it's a first instance case called Coulson, but actually what it does, it synthesises various largely appellate cases in determining how one looks at meaning and opinion in a libel claim. You'll find that at paragraph 29 of the claimant's skeleton, which is page 34 of the bundle.
As you probably know, this is not my field.
Of course.
Why do you determine meaning of part of the publication and then ask whether it's fact or opinion?
The meaning,
rather than looking at it as a whole. I mean, if I say, in my opinion, the government is a shambles, the meaning of what I've said is not the government is a shambles. The meaning of what I've said is, in my opinion, the government is a shambles. That's the meaning of what I've said. Why do you separate the one bit from the other?
In fact, we don't. In determining meaning, you have to look at the whole of the publication. And again, in determining whether it's opinion or not, you also look at the whole of the publication. So taking your example, I couldn't turn up to court and say, well, just ignore the in my opinion bit, just look at the bit after that.
Yeah.
It's always to look at the whole publication.
Yes, because it seemed to me the judge did chop it up. He chopped up Mr. Tice's words.
Yes, it's difficult. It's difficult in parts. Obviously, it's a judgment we're appealing. We say he's got it wrong. There are parts where it's logically it doesn't follow, but ultimately we're appealing against his decision rather than his reasoning.
Yeah.
And so Coulson sets out the principles how to determine whether something's opinion or not. I've set out paragraph 29 of the claimant's skeleton argument. The first pointer is the statement must be recognisable as comment, as distinct from an imputation of fact. Now, that's particularly important in a case like this, where I'll do the dissection of the words themselves shortly, where one is looking at what, to all intents and purposes, would look to anyone like a bare allegation of fact. What is there in it which would possibly cause the reader to say, well, hold on a minute, this man's just offering an opinion on something else? Particularly so with Twitter, and again, I'll come to an authority stalker on this, where people, it's a statement of obvious fact, retweet tweets quickly. You're not reading a scientific journal or an editorial in the Times. It's an impressionistic medium where messages are sent in very clear terms and read quickly. But then Roman numerals 2, opinion is something which is or can reasonably be inferred to be deduction, inference, conclusion, criticism, remark, observation, etc. Now, the important thing we take away from that is that to be an inference, it's got to be an inference about something. It's got to be a deduction about something. So when you're looking as to whether opinion is actually what you're seeing on the page, it should, we say obvious that what the opinion is about. And if you can't, it's not obvious what the opinion is about, then that militates in favour of finding it's an allegation of fact rather than opinion. Roman numerals 3, the ultimate question is how the words would strike the ordinary reasonable reader. The subject matter and context of the words may be an important factor of whether they are fact or opinion. Now, in this case, looking at the Guido Fawkes tweet and the defendant's tweet about the claimant being pro-Hamas or pro the anti-Semitic terrorist organisation Hamas, we say what you're looking at the page are allegations of fact hitting the reader squarely between the eyes. There's no nuance here. There's no suggestion, for instance, could have been a suggestion that, oh look, Dale Vince has said one man's freedom fighter is another man's terrorist. Some might think from that actually he's supporting or excusing terrorism. There's nothing like that. We say there's a discrete factual allegation made by Mr. Tice at the top of the page. Now, Roman numerals 4 isn't directly on point. I'll just read it out, but it is important for the point I made in regard to Roman numerals 2. Some statements which are by their nature and appearance opinion are nevertheless treated as statements of fact where, for instance, the opinion implies that a claimant has done something, but does not imply what, or does not indicate what their something is, i.e. the statement is a bare comment. One can see from that that it's important that an opinion actually sets out what it's about, makes the link, creates the nexus between the opinion and the fact or subject matter it's commenting on. Now, if I can take you to the defendant's tweet, which you'll find at the supplemental bundle at tab 1, page 3. You'll see there the statement made directly from the mouth of Mr. Tice is that so major Labour donor is pro the murderous anti-Semitic Hamas. Now we say this is just saying what it says on the packet, frankly. Mr. Vince supports the murderous anti-Semitic Hamas. There's nothing there to suggest that this is an opinion. It's factual, it's not evaluative. Now, the judge places weight on the words so and but we say that's just mere fluff. It doesn't really take anyone anywhere. It certainly doesn't make the link to establish in the reader's mind that an opinion is being offered and what's said below. But really what is being done here is that Mr. Tice is just republishing someone else's allegation and just ramping it up a bit. Because if you look at the allegation, the headline, multi-million-pound donor to Labour Party says mass are freedom fighters. All Richard Tice does in his statement by saying so major Labour donor is pro the murderous anti-Semitic Hamas is he just ramps up the allegation. He reinforces it by adding the words murderous and anti-Semitic and the words pro. He's not commenting on it, he's repeating it, he's republishing it. As we say, he's ramping it up. And just repeating someone's allegation like that and clearly endorsing it isn't something that should be defended by honest opinion, because it just isn't opinion. He's just saying, look at this, look what Guido Fawkes are saying about Dale Vince, and also, if I may say so, putting the boot in himself by ramping up the allegation by saying Dale Vince is pro, that means supports the murderous anti-Semitic Hamas.
So is it an impermissible reading of Mr. Tice's own words to interpret them as saying, I deduce from the retweeted Guido Fawkes tweet that major Labour donor is?
Well, we'd say that would be plainly wrong to deduce that, because there's nothing in those words that can take you down that path.
So meaning as a consequence of what I'm retweeting?
Well, but then there's no link. If you just retweet something, you're just republishing those words. So if you start with just the retweeting and you don't add a comment, obviously to a degree you're approving of what you're retweeting. But these words certainly don't suggest disapproval. They're connoting approval. They're really saying, here, look at this. And as we say, Richard Tice doesn't hold back in upping the ante, as it were, by saying he supports the murderous anti-Semitic terrorist organisation, Hamas. Now, I mentioned, just before moving on to the judgment itself, I mentioned the authority of Stocker, which deals with how one would expect the reasonable reader to interpret something they read on social media, including Twitter, or X, as I suppose we should call it. You'll find that in the first bundle of authorities at tab 16. Page 375. And I rely on paragraphs 42 to 45. 42, there'll be a passage there Lord Justice Warby is familiar with from his judgment in Monroe and Hopkins, which was a Twitter libel case. That is, the libel was published in a tweet. And then some words of law occur approving that, and also endorsing an analysis put forward by Mr. Justice Nicklin in the case of Munir and Wood. I wonder if I could just ask you to read paragraphs 42 to 45. And really, this is why it's so important to look at, as best one can in the rarefied atmosphere of a courtroom, try and look at a publication like this and take a first impression from it. Or at least to put one's self in the shoes of the ordinary reasonable reader looking at this type of material on Twitter. Because definitely what won't happen is the reader won't go back to it again and again saying, well, actually, theoretically, this could have meant, so theoretically could have meant, I meant to look at the posting below, and what does mean? Well, theoretically, it could mean that this is a comment. That's not how it would work. We're not analysing a contract here. We've got to be careful to keep our eyes on how the reasonable reader on Twitter would view this. And once one starts having to argue closely that somehow this is an opinion for we say on the judge's reasons, odd reasons, then really you've taken your eye off of what you're meant to be doing, which is looking at that first impression, how the reasonable reader would have read it, going through Twitter on the day in question. Now, the judge gives his reasons for finding its opinion at paragraph 100 of his judgment, which you'll find at page 101 of the core bundle, tab 8. Paragraph 100.1 makes a general statement about quote tweets. A quote tweet where someone's retweeted something and added their own words. But the point is, this doesn't really take anyone anywhere, as I think the judge recognises, because the Mr. Tice or anyone publishing a quote tweet could easily say, oh, look at this nonsense below. It doesn't necessarily imply that an opinion is being offered on the material being set out below. And then 100.2, he says that the oppression is created by Mr. Tice's words that he was offering an opinion on the issue raised in the Guido Fawkes tweet. Now, we just say again, that's plainly wrong.
But that was his impression. He's doing what you have just advocated.
Yes, but it's plainly wrong.
Something wrong. You formed the wrong impression.
Well, he's not saying that's his first impression. That's his impression, and clearly my task is to say that's plainly wrong. When he conducted that exercise, he just got it wrong.
By what metric do you measure that?
Well,
I mean, if my impression
unfortunately,
is different from his.
yes.
He may be right and I may be wrong. How do we calibrate?
There's no neat way, I'm afraid, because every set of words is different. There's countless permutations. Sometimes how you interpret different defamatory publications.
Right. And if there are three of us up here and we form different impressions, what do we do?
Well, you've got to decide how the reasonable person would have read the article.
Well, no, we haven't, have we? We've got to decide whether the judge was wrong.
Well, it's if there is a metric, it's you've got the starting point. You've got to say what would the reasonable person conclude, and see if the judge was so wrong that he was plainly wrong. If there is a benchmark or a way of analysing this, I think that must be a part of the analysis that the court needs to partake in.
I'm still puzzled by how we can decide the judge's impression, which is what he says it was wrong.
Well,
we can say we disagree with it, but does
Yes.
that mean it's wrong?
But there's nothing more I can do, because the judge there just says that's my impression.
Yeah.
Beyond what he says in the next paragraph, you've just got to decide whether that was plainly wrong or not. And clearly, you've got to have an appeal process in these matters, because it can never be enough for judge just say that's my impression. If it's plainly wrong, it's plainly wrong, and we say it is. It goes too far, and it doesn't have any proper basis.
I mean,
And then
that's
he
really
says-
the point, isn't it? Your
Pardon me?
point, that it doesn't have any proper basis to say
Yes.
that's his impression.
Yes. Now, the basis he does offer is at paragraph 100.3, where he says such impression is fortified by Mr. Tice's opening words "so," which implies that what follows is a conclusion drawn from the retweeted material. Now, again, there's no hard and fast, black and white way of analysing this, but we say looking at the words on the page, that conclusion is plainly wrong. One cannot draw the conclusion that Mr. Tice is saying Mr. Vince is a terrorist, supports a terrorist anti-Semitic organisation, Hamas, because of what's said below. Because all he's doing is, first of all, is repeating what's said below. He's not commenting on it. Though we do say he not only repeats, he ups the ante by adding the words anti-Semitic and terrorist. So we say that doesn't take anyone anywhere. And read in context, again, we say it's plainly wrong to conclude that is a statement of opinion rather than an allegation of fact. And the reasonable person swiping through Twitter will not be weighing matters up in such a way as to reach the conclusion that it's an opinion. In regard to paragraph 100.4, the judge just says, as Mrs. Justice Collins Rice said in Bridget, this tweet was robust and opinionated reactive political commentary. Well, that's neither here nor there. This is just a factual allegation about whether someone supports a terrorist organisation or not. It doesn't take the matter anywhere. No one's going to think it's opinion because Mr. Tice might be known to be the chairman of the Reform Party and Mr. Del Vince is known to be a Labour supporter. Opinion doesn't arise for that reason. This is a brickbat being thrown at Mr. Vince by Mr. Tice. My lords, concerning my argument to the effect the second statement, that is the defendant's tweet and the Guido Fawkes article, is also opinion. We just say the same arguments apply. You couldn't conclude that this was opinion based on the fact that the Guido Fawkes article also actually repeated the allegations made in the Guido Fawkes headline, the Guido Fawkes tweet, that the claimant, Mr. Vince, had said Hamas are freedom fighters. Well, I was turning to the second ground of appeal. And this is the point that an honest opinion defence can't be used, if I put it this way, to launder, to protect a discrete defamatory allegation of fact.
Does this second ground tend to undermine ground one? Because if it's arguable that the true analysis here is that by republishing the Guido Fawkes tweet, Mr. Tice was setting out some factual allegations of a defamatory kind,
Yes.
on which he was then expressing an opinion, then the judge was entitled to conclude that the Tice only statement was opinion.
Well, we say no. This is put in the alternative.
Yeah.
But we say no. This doesn't undermine the first argument. Really, what's being added to the equation on here is that the defamatory facts, for instance, the defendant's tweet that Mr. Vince had called Hamas freedom fighters. What we're adding here is the extra dimension. That's a defamatory allegation. And that because it's a defamatory allegation of fact, rather than just an allegation of fact, it must be defended of itself as either being true or being protected by defence other than honest opinion. So really what we're saying, if the basis from which the inference is drawn, if the basis for the opinion is a defamatory fact of itself, that defamatory fact must be proven to be true. If I just briefly deal with the law concerning this before proceeding to the two publications themselves. If I can ask you to turn to the Authorities Bundle 1, tab 2. Page 72, Lord Templeman's speech beginning at the bottom of the page. My lords, the plaintiff alleges that certain of the contents of the letter...
Where are you? You're
bottom of
Templeman?
page 72,
Yeah.
tab 2. My lords, the plaintiff alleges that certain of the contents of the letter by the defendant, set forth with numbered paragraphs in speech of my noble and only friend Lord Keith, were defamatory. I reflected on the reputation of the plaintiff intended to lower him in the estimation of right-thinking members of society. If the contents of the letter were fair comment, then the plaintiff cannot complain notwithstanding that they were defamatory. If the contents of the letter included defamatory statements of fact, however, then the plaintiff will succeed in the action for defamation unless the statements of fact set out in the letter were true. If the contents were a statement of facts and the facts were untrue, a plea of fair comment would not avail, and it is for the jury in a proper case to determine what is comment and what is fact. The prerequisite to their right, is that the words are capable of being a statement of fact or facts. So individual statements of fact set out in the basis must be proven to be true. I've also referred in my skeleton argument to the Supreme Court judgment in Spiller and Joseph and Spiller. Now, the point I make in that is that the application for the respondents, for the intervener role, that's the media, which clearly had an interest in advancing Article 10 as far as they could, they never argued, they conceded that if there is a distinct defamatory allegation of fact in the basis of on what an opinion is based, that discrete allegation of fact must of itself be proven to be true. Strictly speaking, it is not authority, but it's set out in my skeleton argument, and we say that sets out how the law ought to be. Now, there's also the principle much loved in defamation law that one cannot breach the repetition rule. And we say a mischief of what has been published by the defendant in this case is that he's republishing defamatory allegations, factual allegations. And we say you can't do that. Well, you can do it, but you've got to prove that those allegations are defensible of themselves, and you can't rely on an all-encompassing honest opinion defence to do so. I've set out the repetition rule at paragraphs 42, 44 to 45 of my skeleton argument. Paragraph 42, page 42 of the core bundle. You'll see there, paragraph 42, a fundamental tenet of defamation law, the repetition rule is relevant. Where an allegation by a third party is repeated by the defendant, the words must be interpreted by reference to the underlying allegation of fact. And then some more learning on that is set out at paragraph 44 from the House of Lords case Lewison Daily Telegraph. I really summed up in Lord Hodgson's statement there. If one repeats a rumour, one adds one own authority to it and implies it is well-founded, that is to say it's true. Turning to the first statement, that's the defendant's tweet of itself. Mr. Justice Pepperell's finding is that the basis of the opinion is what's set out in the Guido Fawkes tweet. And the Guido Fawkes tweet, as it says, page 3 of the supplemental bundle, multi-million-pound donor to Labour Party says Hamas are freedom fighters. Supplemental bundle, tab 1, page 3.
Yeah.
Now that's what Mr. Justice Pepperell says is the basis for the opinion. But it includes
the embedded interview.
And the embedded interview. But for my purposes, what I want to focus on is the allegation there in the headline you see, says Hamas are freedom fighters. Because we say that's a discrete defamatory allegation of fact.
What if it's an interpretation of what Mr. Vince said in the course of the interview? Would it then be would it then be an opinion?
Well, one would have to read it in conjunction with the interview.
Yes. Well,
Or what he says in the
Mr.
interview.
Vince says one man's freedom fight,
Yes.
terrorist is another
Yes.
man's freedom, and then he's asked, he's put to him that's not the
Yes.
Labour Party position, in reference to Hamas, and he says that's how I feel.
Then you're getting onto the issue of it's a bit rarefied. Can you have an opinion about an opinion? Can an opinion itself, if you say the Hamas are freedom fighters as an expression of opinion, well, that can't be the basis for the opinion as found by the judge.
Right.
And also, I won't take you back to it. You'll recall I took you to what the judge said at paragraph 30 of his judgment regarding the common knowledge as to the nature of Hamas. So one can read into that headline, read into the interview as well. He said it's the headline that counts here because it's the headline which is telling readers what to think. And the headline doesn't necessarily mean, there's nothing in the head. Well, to determine is this an opinion or not, one has to go through the various stages we've gone through this morning. But one of the important things is the interview is only an extract from an interview, and that's quite obvious. The reader will be thinking, well, look, he said one man's freedom fighter is another man's terrorist. Well, that can't be why he's saying in the headline, multi-million-pound donor to Labour Party says Hamas are freedom fighters. That we would say is a freestanding factual allegation. Even if it's an opinion, you run into problems because how can Mr. Tice's opinion defence be based on an opinion on an opinion? If that's an obvious point to make. I know it sounds somewhat rarefied, but that's a logical conclusion of where you go if you decide that that headline is an opinion.
I'm sorry, I don't quite follow that. Why can't you have an opinion on an opinion?
Because an opinion must be about something that's factually true. Well, if I say because that's the law, it's you can't.
That is the law, is it?
It's. I haven't got section 3.
Doesn't sound like real life to me. I mean,
Well,
I know in the course of my professional career, I've been presented with counsel's opinion, and I've said, in my opinion, that opinion is wrong.
Yes.
I mean, that's life.
Yes, but this is the nature of the defence means you are making the normal defence in a libel claim is the defence of truth. Is a factual allegation true or not? In an honest opinion defence, a defendant is being given some latitude because they might have said, I give an old-fashioned an example from 1980s. That man banks with Barclays Bank. Barclays Bank operates in apartheid South Africa. Of itself, that's probably not defamatory. But someone's got the leeway to then say that man banks with Barclays. Barclays operate in apartheid South Africa. Therefore, I conclude that man is a racist because he banks with them. It's a harsh judgment, but it's fair, it's honest, and it's an inference, a deduction drawn from the fact. You need to deduce from make a deduction or an inference to something factual. You can't have opinions on opinions or opinions because that would give the defendant endless leeway and not really benefit readers either. You've got to, even an honest opinion defence has got to have a basis on fact. And the basis on fact is why the existence of that gives the defendant great leeway to make comments as long as it's clear the inference or the deduction is being drawn from that fact. So we very much say that you can't have an honest opinion defence where the basis of the opinion is itself an opinion. So given that, on our case, there's a discrete defamatory allegation of fact there, the defendant must prove that to be true. And the judge could have done two things at the first instance hearing. He could have found a discrete allegation of defamatory effect, and working on the basis of how what the judge concluded about the common knowledge about Hamas. The judge should have concluded in regard to this material that Mr. Vince has said that the terrorist organisation Hamas that carried out mass murder kidnapping and rape in October 2003 are freedom fighters. So just taking the statement, Mr. Vince has said Hamas are freedom fighters, and putting in the other information in the same way as Mr. Justice Pepperell did in the claim against Mr. Staines. Alternatively, I've set out at paragraph 54 of the claimant's skeleton argument a different way of dealing with it. And that is it's quite common practice in defamation claims following a trial of preliminary issue in the defamatory meaning to incorporate the statement of fact and the statement of opinion, but to underline the statement of fact. So you see there 4 lines from the bottom. Another way of dealing with this is to replace the judge's meaning or add these words in front of it, these factual words, by saying Hamas are freedom fighters. The claimant supports the murderous and anti-Semitic terrorist organisation Hamas. Of course, we would say, just as it's the case in a first instance hearing, that ultimately the trial judge can determine the meaning that he or she chooses, the same latitude should extend to this court. Though, of course, what we've done in our appeal is we've accepted the judge's meaning. We've just said he's characterised it wrongly as opinion. And also, if you put it this way, he's missed out a bit concerning the defamatory factual allegations made in the Guido Fawkes tweet and the Guido Fawkes article. Just one thing before proceeding, just going back to ground one important point I forgot to make. Was that whilst one looks at the whole of a publication to determine whether it's meaning or not, whether it's opinion or not, the judge's meaning distills the whole article. And we say, when you look at the judge's meaning, because as we say, it's so obviously fact, that of itself militates towards or suggests a finding that the article as a whole should be viewed as fact as well, if you accept that's a proper distillation of what was said in the publication as a whole. Now, turning to the second statement, which is the defendant's tweet, where a subset of readers would also have followed the hyperlink through to the Guido Fawkes article. I've taken you to the meaning of the Guido Fawkes article, which essentially, for our concerns, is set out paragraph 48.2 and 48.3 of the judgment. The really important one being 48.3, being that the claimant believes, and has said on Times Radio, that the terrorist organisation Hamas that carried out mass murder, kidnapping and rape in October 2023 are freedom fighters who should have the right to defend themselves. Again, the judge found that was a statement of fact and it was defamatory. Now, again, we say that is the arguments concerning when you look at the defendant's tweet by itself apply even more so when you look at those readers who read the defendant's tweet and the Guido Fawkes article. Because first of all, you've got a finding by the judge that the article is factual. But even more importantly, you've got a finding that it's also defamatory. And we say, simply because Mr. Tice added his own statement at the top of his tweet, that cannot convert the Guido Fawkes article with the very serious defamatory allegation it makes there into opinion. This is, as said in Telnikov and Matusevich, thank you very much. You can't protect very serious allegations like this under the umbrella of honest opinion, when of itself, as found by the judge, it's a serious defamatory allegation of fact. Now, you could, again, one option available to your lordships, if you're finding in favour of the appellant, is simply to add the meaning found by the judge at paragraph 48.2 of his judgment that I just read out. or we've advanced at paragraph 52 of the judgment, a blended meaning, which follows the course normally adopted in judgments following trials of preliminary issues, where the allegations of fact and opinion are set out, with allegations of fact are set out and underlining. So that's a
What you've got in the tweet is a hyperlink, as I understand it.
yes.
If you want to incorporate the contents of a hyperlinked article into the publication, do you need to have some evidence that anybody actually clicked on the hyperlink? Or is the mere fact that there is a hyperlink considered in itself to be a republication
Yes.
of what you would find if you were to
Yes.
click on the hyperlink? As I understood the law, there is quite a lot of doubt about that.
Well, as matters currently stand, fortunately for us, that's an issue for trial. It's first of all would depend on inference. The number of people who read the tweet itself was just under 590,000. It would, we would say, be reasonable to infer that a substantial proportion of people who read the tweet would have followed the hyperlink. Then one's got to consider how one again would read the defendant's tweet. Is the defendant's tweet, particularly the Guido Fawkes tweet, is that obviously a headline to an article, which in fact it is, as you find out when you follow the hyperlink. And to what extent, if a hyperlink is offered, would you expect a proportion of readers to follow it? So at the very least, we would say there'd be an inference that a substantial proportion of people, and this is part of the claimant's pleaded case, would have followed the hyperlink and in fact read the Guido Fawkes article.
I'm just puzzled by what the judge says at paragraph 80 when he says that no one's argued the meaning of Mr. Tice's tweet is affected by whether the hypothetical reader clicked on the tweet.
I would say that's a misunderstanding.
Now you seem to be saying, well, it is, because the meaning of Mr. Tice's tweet incorporates by reference the defamatory factual allegations found in the Guido Fawkes article. Well, that would be bound to change its meaning, wouldn't it?
But the way the trial preliminary issue works, both sides put forward their rival meanings. Both sides said each publication bore the same meaning. Now, what the judge has wrongly done is almost assumed he has to find the same meaning. And it was suggested in our appeal to the judge for permission to appeal that he hadn't taken account of the Guido Fawkes article. But he was emphatic in his grounds for refusing appeal that he had. And clearly paragraph 80 says he did read it. Just because both parties say it means the same thing, that doesn't absolve the judge of the responsibility of reading each of the whole publication. And what one's got to bear in mind is that the claimant, me at the initial hearing, was also arguing fully for what the Guido Fawkes article meant. That was part and parcel of the argument. And the argument was that it meant, I think, more or less the same as the judge found it to mean, and that it was a defamatory allegation of fact. If the judge had made a mistake, he seems to have, because both sides are putting forward the same meanings, he perhaps closed his mind to the effect of the Guido Fawkes article. And neither party could be expected to predict the outcome of the judgment. Both parties just put forward their single meaning. There are countless permutations. It so happens that the judge, from our point of view, unexpectedly has come up with this particular permutation. But that doesn't mean that somehow he's absolved from the fact there were discrete defamatory allegations of fact in the Guido Fawkes article. And the fact is, this was all heard together. The evidence is in the judgment. We were arguing the Guido Fawkes article was of itself a defamatory allegation of fact. But the blended meaning, you see, for your consideration, and ultimately if you're with us, it will be for the court to determine what the meaning actually is. But you'll see we've taken the judge's meanings regarding the Guido Fawkes article and then really added over the page in the ununderlined part his conclusion on meaning, but just added the words therefore. But again, there are, as ever, various permutations in the way you could deal with that.
As I understand it, I mean, it's quite important for us to understand, I think, what it was that you did argue. I mean, you say we don't let the judge off the hook by arguing it in a particular way. But if you can find your argument on meaning to something that didn't include, well, this is a repetition rule case, is it not open to the respondent to say, well, you're running a new case now?
My lord, I didn't, and I'm going to take you to the reasons for that now. But it does raise an issue that I haven't come across before. I haven't seen it occur in the authorities. It's just the problem is that neither party knows the meaning the judge is going to come up with. If the Guido-Fawkes claim had been determined first, it'd be much more straightforward, but it was all determined together. And
Well, also, if you'd sued on the tweet and the judge had made a finding about what that meant, whether it was fact or opinion, it would all be a lot simpler. If you sued the Guido-Fawkes on the tweet, but you didn't. And so we don't have a finding from the judge on what that meant or whether it was fact or opinion.
No, it's a lot of balls in the air, I'm afraid, but it's just the way it is when you're trying to determine issues like this. What I'm going to do now is go through some points in the defendant's skeleton, really in regard to the issue raised by my Lord Justice Warby about how the case was put at the first instance. If I could begin with paragraph 41 of the defendant's skeleton argument, which you'll find at the core bundle, tab 5, page 60. That's page 60, bottom of the page, paragraph 41. Which is saying the claimant skeleton argument. It quotes the claimant skeleton argument there in italics, adding the GF tweet to the defendant's statement. It's a major Labour donor to probe the murders.
We have read it, Mr. Bennett.
Oh, pardon me. But you'll see then the criticism made over the page after the italics finish, criticism by the defendant. If the Guido-Fawkes tweet contains a discrete factual defamatory allegation, it was only lauded because the claimant chose not to complain of it. Well, that's not right, because the whole of the statement was complained of. And as is normal in a libel claim, one advances meanings which synthesize the whole of a publication. And I took you to the particulars claim at the outset, but clearly the words, the claimant supports Hamas, were set out in the words complained of. And in fact, the meaning complained of by the claimant does pertain and refer to the claimant's, Mr. Vince's alleged support for Hamas. Paragraph 44 of the defendant's skeleton argument. Again, it quotes from my skeleton argument in italics.
Yeah.
And then over the page, after the italics finish, it says, it was evident, and that's a reference from the amended particulars of claim, the Guido-Fawkes article was only being relied on for reference, as it named the claimant. That's not correct. The amended particulars of claim make it clear that the article referred to the claimant, Mr. Vince, by name. That doesn't mean that was the only reason Guido-Fawkes article was being referred to. Paragraph 45 it says the parties in the three claims. That's the claims against Lord Bailey, which has been discontinued. Claim against Mr. Tice, claim against Mr. Staines. Agree to trial preliminary issues that there were disputes as to their ambit and listing. The court therefore listed a review hearing before Master Dagnall on the 23rd of October 2024. The defendant submitted that the trial preliminary issue should determine whether the reasonable reader would have access to the Guido Fawkes article. The claimant objected on the basis that the article was only being relied on for reference, not meaning. If I can take you to the skeleton argument that's being referred to there in the footnote, which you'll find in Supplemental Bundle, tab 10. Page 49. If I just ask you to look at the last sentence of paragraph 11, this is the claimant's skeleton argument before Master Dagnall. It says quite clearly, at the trial of preliminary issue, the court should determine how the reasonable reader interpreted each of the publications, i.e. A and B. And A was a reference to the defendant's tweet, and B was a reference to the defendant's tweet and the Guido Fawkes article. So it's spelt out clearly from the beginning that the whole of each publication would have to be assessed for meaning. And in fact, the judge quite rightly in his judgment, I won't take you to it because it's standard law set out in Coulson. The judge always determines a publication by reference to all of the words in the publication, not any that the claimant tries to cherry pick. And just then about 7 lines up from bottom of paragraph 12, where it begins, it is important. It's important to note in the instant case, what matters is that the multi-million-dollar article names the claimant. That is why it's relied on by the claimant, because it would cause people who did not recognise the photograph of the claimant in the tweet to know that it's the claimant who's being defamed. On the instant facts, the court is unlikely to conclude that the meanings of the tweet by itself and the tweet, when read in conjunction with the article, are different. In fact, the claimant relies on the same meanings, as does the defendant, I interpose. See, we just say unlikely. And clearly, from our point of view and the defendant's point of view, because we're putting forward saying each publication bears the same meaning, it's our case, it's unlikely. That doesn't rule out the possibility, the likelihood, that the judge would disagree. Now, paragraph 50 of the defendant's skeleton argument, which is on page 6.3 of the core bundle.
If we are going through this, which I will have to do, I think it's important to look at 47 as the key paragraph, rather than just jump over it.
Well, you can do that shortly.
You'll have your chance, Mr. Price.
Just easier if we go.
We've read the skeleton argument.
Yes.
We can see what paragraph 47 says.
I'm grateful for that.
Yes, well, I'm going to turn to an extract from the transcript shortly.
Paragraph 50 you want us to look at.
Paragraph 50, it says the judge accepted the claimant's submission that it was unnecessary to determine whether the reasonable reader would have access to Guido Fawkes' article, as it did not impact on meaning. That's simply incorrect. It's recognised in the judgment on the authorities that the whole of the publication affects meaning. It's recognised in our submissions, as stated in the submissions to Master Dagnall, that was the correct position. And if you look at judgment paragraph 80, which I've taken you to, the judge does say that he did read the Guido Fawkes article.
Yes, but he also says that nobody's argued that the meaning of Mr. Tice's tweet is affected by whether the hypothetical reader clicked on the Guido Fawkes tweet. Now, if the material in the Guido Fawkes article, hyperlinked in the Guido Fawkes tweet, is incorporated into the publication, I would have thought it is obvious that the meaning is different because it includes additional allegations. And if nobody is arguing that the meaning changed, then...
With great respect, it doesn't include additional allegations. The only extra words are that the Hamas, not the Palestinian, Hamas had a right to defend itself. As I'll take you to in the transcript submissions, I did submit that was relevant to the meaning. I said it, we still stuck by the fact that each publication had the same meaning, but those words reinforced the meaning, made it even more obvious. But of course, ultimately, we didn't know what the judge would ultimately find the meaning would be.
Right.
And then paragraph 70 of the defendant's skeleton argument. Paragraph 70, that's page 68 of the core bundle. The first sentence can be ignored, but then it says, it seeks to impose a duty, that is the claimant, not merely assert a power, on the judge to add a discrete, unpleaded meaning to the claim, which would necessarily involve a further determination of fact opinion, therefore increasing costs and court resources at the trial of the preliminary issue and beyond, when the claimant could have complained of the meaning but told the judge he did not need to, because the meaning he was complaining about was sufficient. Well, that is great respect to distortion. We put forward a meaning which we said was borne by all of the words complained of, and the meaning we put forward, as made clear in the particulars of claims, set out clearly, included the fact, or words to the effect, that the claimant had said that Hamas are freedom fighters and that the claimant supports Hamas. That was the very sting of the libel complained of, whether one just read the defendant's tweet or the defendant's tweet in conjunction with the Guido Fawkes article. And of course, yes, the claimant or the defendant could have pleaded multiple meanings, but the normal practice is, and we'd say in these circumstances it's the right practice, is to plead one single meaning for each publication. And that single meaning we pleaded is still in play before you today. We're not asking for a different meaning than that we pleaded. All we've done is, rather than try and tear up the whole of the judge's judgment, is to accept the meaning he found and work around that, but on the basis that's an opinion. And if it's not opinion, then it can still stand on the blended meanings advanced in the skeleton argument, but one can't ignore the discrete defamatory allegations of fact, which were also made in the words complained of. And really, this is the nub of the defendant's complaint, saying that we failed to add a discrete freedom fighters meaning, but actually that sting has always been front and centre of our case. Our pleaded meaning has always been that the claimant is alleged by the defendant to have supported Hamas.
But isn't that, part of your argument is that an allegation that as a matter of fact, he has expressed support for Hamas by describing them as freedom fighters. Part of your argument is that that is a distinct defamatory imputation of fact.
Well, it's wrapped up
in the pleaded meaning. It's in the pleaded words, but it's not in the pleaded meaning.
Can I just look at the pleaded meaning? Well, it's our interpretation of saying Hamas are freedom fighters is that the claimant is expressing support for Hamas. And that's at paragraph 14c of the meaning. And by doing that, we've accorded with the proper role of a pleader in a defamation case in distilling the sting. And the sting is if you say that Hamas, which is a matter of common knowledge, is a terrorist organisation that committed the atrocities of the 7th of October, if you're saying they're freedom fighters, then it's perfectly reasonable, proper to plead that meaning that the claimant supports Hamas. Then the following words, an anti-Semitic prescribed outlaw terrorist organisation which murders Jews because they're Jews, which actually accords with, doesn't exactly accord, but certainly largely accords with the meaning found by the judge. It wasn't incumbent upon us, and we couldn't look into a crystal ball all that time beforehand to start coming up with different permutations. Our task was to plead one all-encompassing meaning that captured the sting of the article. And we say the sting says Hamas are freedom fighters is caught up in paragraph 14c. So that therefore we stand by that point. The sting has always been there and still is there in the pleaded case. Though clearly, by reason of the judge's judgment, matters have moved on. And if I just take you to the claimant's skeleton before Mr. Justice Pepperell, which you'll find at supplemental bundle, tab 16, page 106.
Paragraph.
Or 39 at the bottom of the page. You see, it says the defendant's tweet reported matters of fact. Defendant is emphatic. The claimant is pro the murderous anti-Semitic Hamas. That's the Mr. Tice's statement at the beginning. The claimant is an extremist donor and is reported that the claimant has said that Hamas are freedom fighters. That's
paragraph is it?
paragraph 39 at the bottom of page 106 of the supplemental bundle. So we say it couldn't be more emphatic there that we are referring to the Hamas are freedom fighters and how that is tied up in the meaning and also contributes to the fact that a finding shouldn't have been made that this was opinion. And then over the page at paragraph 42, page 107, core bundle, paragraph 42 of the claimant's skeleton argument before Mr. Justice Pepperell, it says there, the defendant cannot rely on the 16-second clip of the interview and bypass the headline that the claimant in fact stated that Hamas are freedom fighters. Again, that's quoting from the defendant's tweet. It's the allegation that Hamas are freedom fighters again. If contrary to the claimant's main case, there is an expression of opinion, it must at least be placed in part on this headline, that Hamas are freedom fighters. And I mentioned that I would take you to the transcript before Mr. Justice Pepperell. Which you'll find in the supplemental bundle, tab 12. Supplemental, tab 12, page 63, 63. It's internal pages 29 to 30, if I may just read that out. These are my submissions to Mr. Justice.
Just tell us what you want us to read and we'll read it.
Oh, pardon me. Internal paragraph 29, bottom left,
Yeah.
through to the end of internal paragraph, page 30 at the top right-hand corner.
29, line 21, is that where you want us to
No,
start?
29, page what? Sorry,
Line
page
one.
29, line 1,
Line 1.
through to line 19 of page 30. You see the first part, again, making great play of the fact that the defendant's, Guido Fawkes' tweet of itself refers to the fact that Mr. Vince has called Hamas freedom fighters. I refer to that as one of two headlines, paragraph 15. line 21 onwards, I refer to the fact that the judge has already been taken by me through the Guido Fawkes article. And then importantly, making good my earlier submission, I say that the Guido Fawkes article reinforces the allegation by including what we say is a false statement, that Mr. Vince is said to have said that Hamas has a right to defend itself. They are words from the Guido Fawkes article, which again we say is obviously a reference to the 7th October. We're saying that's an allegation of fact, and we say that's a Chase level 1 allegation of fact. We don't say it's defamatory there, but clearly part and parcel of my submissions regarding the meaning of the Guido Fawkes article, our submissions were that it's defamatory. Therefore, you can see there, in this part of the hearing, which is dealing specifically with the claim brought against Mr. Tice, I'd be absolutely emphatic there that the contents of the Guido Fawkes article matter. I'm not saying it changes the meaning, because we still say it doesn't, it reinforces it. But it reinforces it by reason of that reference to Hamas having a right to defend itself. And right through to line 19 there, we say is relevant. That's how the case was actually put on behalf of the claimant before Mr. Justice Pepperell. My lords, that covers everything that I was intending to say. Is there anything you would like me to deal with before I sit down?
Thank you very much. Yes, Mr. Price.
My intention is to take ground 1 first, then ground 2, and then the respondent's notice, if necessary. I'm conscious that I'm advocate for the respondent, so I'm very happy to go in any direction the court will find to be of assistance. I'm relying on authorities in civil procedure generally, when my lords, Lord Justice Lewison and Lord Justice Coulson, have probably the most expertise, one of the greatest expertise.
Lord Justice Warby.
Well, I mean, I was coming on to Lord Justice Warby, because my point was that Lord Justice Warby has either decided or been the advocate in most of the defamation authorities. So if I was just making my submissions on defamation law to Lord Justice Warby, I could go through them fairly quickly, but I was proposing to take them at a pace of for somebody who was not a defamation specialist. Although this case is incredibly straightforward, it actually really just turns on civil procedure in many ways. Once one deals with the opinion point, which is actually not a question of defamation law, my learned friends' submissions raise issues which, if they were endorsed by this court, would fundamentally affect the defence of honest opinion. But this case simply turns on whether it's perverse of the judge to regard the RT tweet, as I call it, as a deduction from the GF tweet. Clearly it wasn't perverse, and that's the end of it. So before I start with ground 1, can I just go to the definition section in my skeleton argument, because it is really important that we have clarity here. And my learned friend, with respect, did further confuse the matter by saying initially that the RT tweet, in other words, my client's own words, encompassed the GF tweet. But then, in the course of the submissions, referred to, well, if you read the Tice tweet and then read the Guido Fawkes tweet, so thereby drawing a distinction between the two. We have to draw a distinction between the two in my submission when analysing this case. So I'm going to start with my skeleton argument right at the very beginning. It's 550. I'm obviously not going to read it, but we start off with the interview, which is the factual material on which this opinion defence is based and without which there wouldn't be a claim. If Mr. Vince hadn't spoken those words in that interview, none of this would have happened. So there's a full interview. I define that as the interview, which was available and I think possibly still is available on the Times Radio website. There's a transcript of it in Mr. Justice Pepperell's judgment. There's also an analysis in the draft defence in Bailey, which explains why this interview actually conveys the meaning that Hamas are freedom fighters, or certainly that an honest person could hold that view. And that, if you want to have a look at it, is in the unagreed bundle at tab 3, page 34. So it was relied on by Bailey, because in Bailey the case jumped a little bit further forward because there was a determination that an honest person could hold the opinion that Hamas are freedom fighters on the basis of the words used in the interview. So that's why it was before the court, and it's drafted by me as it happens and likely to be relied on, should it need to be relied on in this case. But the full interview obviously wasn't before the readership of the Guido Fawkes tweet. What we had was the video, as I've defined it. So that's a 16-second video. On the right-hand side of the screen, you get the segment from the interview. On the left-hand side, you get the box, multi-million-pound donor to the Labour Party, says Hamas are freedom fighters. So clearly, the freedom fighters meaning, as I call it, is within the video. No question about that. We would say it's obviously a deduction from the words spoken, as you can see them in the section of the interview. Clearly doesn't say it literally, it's an interpretation, that's obvious. So I did suggest that the video should be viewed. I'm grateful for the indication that has been viewed, and you can see the emphasis on the claimant's words. The answer I've defined is, I think one man's freedom fighter is another man's terrorist. Right, that's how it works. I mean, that's the key point. But there's other stuff, even within the segment, like the acceptance is the opposite of Labour's position. That's how he feels. So I now come on to the definitions, the elements of the publication. The first is the GF tweet. I'm starting with that. That's his post, which has the words, while we're on the subject of extremist donors and returning their donation, followed by a hyperlink to the GF article. And I'll go to it when I go to the RT tweet, as I define it. The RT tweet is just the defendant's own words. And the focus below, on fact and opinion, was solely the defendant's own words. That's what it was all about. It's obvious when you look at this. And in particular, the word pro. If we can go to supplemental bundle 1.3, please. Because this is what the ordinary Twitter or X viewer is seeing when they access my client's tweet. The video plays automatically. The viewer doesn't have to do anything to get the video. It's playing on loop, obviously drawing attention to the video as the main topic of the tweet. I only have to show that it's not perverse for the judge to conclude that my claimant's words were a deduction or interpretation or a reaction to a conclusion on, I think the judge said conclusion on Guido Fawkes' tweet. And of course, mainly the words used by the claimant, which are the most prominent part, which the reader gets hit with on loop. You can see there that most of the Guido Fawkes tweet is visible, but not the full hyperlink. So to get to the hyperlink, so I'm moving on to the Guido Fawkes article, the reader will have to do 2 clicks. He's already getting the video without doing anything, just by accessing my client's tweet, the RT tweet. He's then got to click on the Guido Fawkes tweet, GF tweet as I'll describe it, and then he has to click on the hyperlink. 2 clicks to get to the article. And when I refer to the article, well, we know what that is. My own friend has referred to it. So that's the GF article. There was another article that was sued on. That's not relevant because my client didn't link to that in any way. We have the Staines claim, and then we have the Bailey claim, also relevant when one looks at the meanings that were complained of in the Staines and Bailey claims, which specifically include the discrete Hamas freedom fighters meaning, compare them with this case, and the representations that were made to the judge. So, starting with ground of appeal 1, and I'm going to take it starting at paragraph 22 from my skeleton argument, tab 5, page 57. It's crucial to bear in mind the determination that the judge made was in relation to the RT tweet only. So when he talks about paragraph 80 about other material not affecting meaning or fact or an opinion, he refers that to of the tweet, of my client's tweet, because that's what he's considering. Yes, of course, there are discrete defamatory meanings there, but his role, his role as an adjudicator on the dispute that has been brought to him between the parties is to determine whether my client's tweet, the RT tweet, is fact or opinion, specifically the word pro. So you can see his finding, which I've set out at 22, which
Yeah.
we can go to, but I mean, the tweet is quite clearly defined as just the RT tweet. Now, that-
Defined by who? By the judge?
by the judge, yes. Should we go to that?
Because the particulars of claim talk about the defendant's tweet,
Yeah.
which, as I understand it, incorporates the Guido Fawkes tweet.
Yes. But it,
So there seems to be a bit of a definitional cross-purpose.
yes, but I mean, the reality is that the judge said, "Are you complaining about anything additional from the video or the article?" And he said no. So, but I mean, just it's important though to take it in stages because there's a different. The first question is, what did the judge find? Was he entitled to make that finding? And then the next question is, well, should he then have found something else?
Yeah.
So we start off. What did he find? Quite clearly, his finding related solely to the RT tweet, and we can go if we go to the order itself, which is at 777. The relevant when we start. In fact, we start at 777 in the core bundle.
Yeah.
So he defines the tweet in the recitals.
I looked at that, I thought that was not crystal clear.
But it is when one comes on to the basis for the opinion. If one goes on to,
Okay. There's the first recital, that's what you were.
well, that's the starting point, yeah. And if you turn over the page, you see his determinations. The tweet is a statement of opinion. That's the second one. And then the third, the tweet indicated the basis of the opinion, namely the tweet, quote tweeted, reproduced by the tweet by @Guido Fawkes.
Yeah, it's that third order that
Yeah.
affects what would otherwise be.
Yes, I mean, I just we went through the hearing and it was obvious that it was the whole dispute was around the word pro and whether my client's words had to be viewed in isolation or it was possible to view them as a deduction on what the claimant had said in the interview. But in any event, it's quite clear from this that the only determination the judge was making related to the RT tweet. So the first question you've got to ask is, was that determination open to him? And then the second question you've got to ask is, has he made an error of law, or was he wrong not to have gone on to found a discrete defamatory meaning in the GF tweet or the GF article?
Yeah.
That's the issue for this court. So I see ground of appeal 1 as really being directed to the word pro and the RT tweet alone, and ground of appeal 2 being directed to additional discrete defamatory imputations elsewhere.
Yeah. Well, I think you get that from paragraphs 80, 86. 94 of the judge's judgment.
Yeah, well, 80, he says, well, further, no one has argued that the meaning of Mr. Tice's tweet is affected by whether the hypothetical reader clicks on the Guido Fawkes tweet.
Yeah, and that seems to be reflected in what Mr. Munden was recorded as saying at 96.
Because
those are factors in the GF tweet which the judge thinks are not being complained about.
it's important to bear in mind that the video plays when you access the RT tweet. So you see the claimant's words.
Yeah.
And then he makes a distinction between Mr. Tice's tweet, Guido Fawkes's tweet, and then sort of 3 lines up from the bottom of 80. Like counsel, I conclude that consideration of the additional hyperlink material does not affect the meaning of Mr. Tice's tweet. Which is clearly right. None of the parties were saying that it did, and it obviously doesn't affect the meaning of Mr. Tice's tweet. It may give rise to a discrete defamatory imputation, but that's a separate question about whether it affects the meaning of Mr. Tice's tweet and whether that tweet is fact or opinion. Because, as I say, the court's first duty is to consider whether the judge was perverse to conclude that the word pro in the RT tweet was opinion. The second task is to say, well, was he wrong not to go on and find a discrete defamatory allegation, which, let's face it, is the freedom fighters' meaning. I mean, that's the only one it can be.
While we're on this, could I just ask you about paragraph 94 of the judge, where the judge is recording what he understood Mr. Bennett to argue. And up to the end towards the end of the second line of that paragraph, it's all consistent with your submission. But he then records an argument that Mr. Tice's tweet ... asserted ... that he is an extremist donor, that he had said that Hamas are freedom fighters, and those are bits that come from the GF tweet, don't they?
But the point was being made that there was an emphatic tone, and the emphatic tone continued into the GF tweet. That's a very different thing from saying, I want to advance the freedom fighters movement. The focus was solely on the RT tweet.
Yeah. Well, you're going to take us to other material on that one.
Yes, but I mean, I think I'm going to do that within ground of appeal too, if I may.
Yes.
Because
I'm not
conceptually,
really-
I say,
I'm not trying to take you out of your course.
but I can. I'm happy to deal with it now. If
No,
you help.
I think I'm best, from my point of view, just follow your own.
So I'm still on the first question, I think, which is, was the judge perverse to find that the RT tweet was a statement of opinion? And there's a distinct question as to whether he should have gone and found some other meaning. And on the first question, there's a huge amount of jurisprudence on the question of public figures making controversial statements and other people responding to them, and that being more likely to be treated as opinion. And I can go to those authorities. They were touched on by the judge. I'm going to start by simply saying this. The key finding is at 102.2 and 100.3, which is at 8.101. It's an appeal based solely on an error of law. Oh, sorry, not on an error of law, rather. It's based solely on a perverse conclusion. So the judge has gone through all the authorities. There's quite a lot of authorities on political speech and the distinction between fact and opinion. So quite difficult to see, if he hasn't made an error of law, how he's come up with something perverse when he says the impression created by Mr. Tice's words that he was offering an opinion on the issue raised in the Guido Fawkes tweet. Such impression is fortified by Mr. Tice's opening words so, which implies that what follows is a conclusion drawn from the retweeted material. I mean, my submission, that is obviously right. One doesn't determine opinion, fact opinion, in a sort of vacuum, in a sort of parliamentary justice way. Oh, what's my impression about this? There are legal tests, well-established legal tests as to what constitutes opinion. It's why my Lord Justice Coulson in the recent Curry case observed that there was an element of artificiality in the distinction between an allegation of fact and an allegation of opinion, because a reader doesn't go through an article saying, oh, is this an opinion or is this a statement of fact? No. The law has to draw a distinction, because if you want to protect people's right to express opinions, you have to make the defence relatively easy to succeed once the words are held to be opinion. But on the other hand, there has to be a distinction between opinion and fact, and the law has to draw it somewhere, and there's quite established jurisprudence on that. But the key test is, as referred to in the Coulson case, but it's long-standing before that. And find that when the judge considers the relevant principles on opinion, which is at page 85, so it's paragraph 19. Paragraph 2. This is a definition of opinion. It's been upheld by the Court of Appeal. I think it's been around for very many years. Opinion is something which is or can reasonably be inferred to be deduction, inference, conclusion, criticism, remark, observation, etc. So it's a very high standard of appellate review, a determination of this kind. And it's been emphasised more recently in a Privy Council case, which is in the bundle, which is perhaps worth having a quick look at. Before I go to it, it's often said by an appellant in cases of meaning determinations or fact opinion, look, the appellate court's in just as good a position as the trial judge. There's not a situation where there's been witness evidence or there's a whole series of things that have been balanced. So you should be more willing to overturn a decision if you think it's wrong, because the trial judge hasn't had any great advantage than you. I've cited a passage from Lord Reid in Henderson and Foxworth, which I'm sure will be very familiar to this court, which involved a case of primary fact based on witness evidence. Right? It does not matter with whatever degree of certainty the appellate court considers that it would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. And the Privy Council have recently made clear that this same test relating to witness evidence and findings of primary fact applies to the determination of meaning. And that case is Alexander and Gabriel, which is in tab 34, which is, I think, is the second bundle of hard copy, and page 702 on the electronic bundle.
Sorry, page.
702, so it's tab 34, volume 2 of the authorities bundle, or page 702. So this was a claim involving political opponents in Trinidad and Tobago. The Court of Appeal there had reversed findings that the statement was defamatory and also awarded nominal damages. It's Lord Leggett who gave the judgment. And perhaps we can start at paragraph 10, page 705. You can see there, 10.1, where the Court of Appeal was justified in reversing the judge's finding that the first statement was defamatory, etc. And then Lord Leggett goes on to deal with the relevant law on defamatory meaning. And then at 14, he talks about the role of the judge. And of course now, we only have judicial determinations of meaning. There's no jury to have to worry about. And perhaps I can just ask you to read 14 and 15.
The point about paragraph 14 is that the meaning of an allegedly defamatory statement is a question of fact. That's why it was decided by the jury days when juries tried these cases. And that feeds into an appeal on the basis that an appellant is asking an appeal court to reverse a trial judge's finding of fact. And that brings in your Foxworth point, that it's only if there is no rational basis for it that an appeal court can interfere.
Yes. But I would accept if there's some identifiable flaw of reasoning, I think is the language used in some of the Court of Appeal cases.
That's a sprint room test, yes.
Yeah, but potentially if there's you can see an identifiable flaw in reasoning, that may be a route in. I would still, but there's clearly no identifiable flaw in reasoning here. The relevant reasoning is the judge's reasoning that the RT tweet strikes the reader as something referring back to the GF tweet, in particular
I mean,
the video.
I find it difficult to see by what metric one can say that's irrational.
I mean,
The judge is really saying this. He's probably not saying much more than that's how it strikes me.
yeah, it's a simple case. It's obviously it's a quote tweet. I mean, look what the claimant said. I mean, Lord Justice Warby in Blake and Fox said that's what a quote tweet does. It says, look what this person has said. It's obviously a reference back. So, I mean, it's a bit of a
The
hostage.
additional point here, because I think this is one of the points made in Stocker, that even if the appellate court is in as good a position as the trial court, that's not a good reason to do it all over again,
Yes.
because the system depends on a certain degree of respect being paid to the first decision.
Yes, I mean, that was
And that's
submission.
the point being made in this passage from Anderson and the City of Bessemer, isn't it?
Yes.
It's unfair.
I mean, that was a submission made in Stocker that the appellate court's in as good a position. And the trial judge, so you should be more willing to get involved. And I think there was some support for that in some of the authorities potentially. But now, consistent with scarce resources and cost and the emphasis now modern litigation, this is it's not a show, it's not a rehearsal, it's the main event kind of that one sees in the jurisprudence. It's a very high test, and it's obviously not satisfied on the facts of this case. And there's a bit of a hostage to fortune in my skeleton argument. I said there has been no case where this court has overturned a finding that words were opinion, either in the era of the Section 3 defence or the common law defence of fair comment. Hasn't happened absent some error of principle, and none is alleged in this case. The judge's citation of the authorities was immaculate and cannot be criticised.
Yeah.
So I was going to move on to ground of appeal 2. I mean, they're all in my skeleton argument, but the idea that an opinion has to be obvious to it has to somehow we can add the word obviously to Section 3.2, which is the statement of opinion, obviously a statement of opinion, or there has to be something explicit that shows it's an opinion, or lucky defendant, you're being given this right to make opinions, and you've got to be very careful, and you've got to say this is my opinion. All this stuff that was the arguments that made in Joseph and Spiller about this defence has to be interpreted in a way that's fair to a claimant. They're all rejected. It's just 3 conditions. That's how fairness is achieved to a claimant, and the most important one is that the words are recognisable as opinion. And just because we may get onto the Guido Fawkes tweet, my primary submission is that we just don't get onto called Hamas freedom fighters in the Guido Fawkes tweet. But Telnikov is absolutely crystal clear of the distinction between opinion and fact in these cases, which is the defendant reporting or purporting to report what the claimant has said, or is the defendant saying this is the effect of the claimant's words? I think I perhaps ought to go to Telnikov because it's crystal clear in that case. So Telnikov is in the first bundle of authorities at tab 2, page 60.
Page 60.
Yes. It's a fairly straightforward case. The plaintiff wrote an article in the Daily Telegraph. Defendant objected to it, wrote a letter, which was published in the Daily Telegraph. Question of law was in determining whether the letter is, or the relevant parts of the letter are opinion, do you assume that the ordinary reader has the article in mind, or do you just look at the letter? And the Lordships decided that you only look at the letter And if you only look at the letter, then the words are capable of being factual. So what's being attributed to the claimant or the plaintiff is something that he actually said, rather than an interpretation of it. Therefore, it needs to go back in front of a jury. So we just have to look at the letter itself, which starts at 349H. Yeah, so that introduces it. And then you turn over the page to 350, you can see the letter. And the crucial paragraphs are 6 and 7. Mr. Telnikov demands that in the interest of more effective broadcast, the managers of the BBC Russian service should switch from professional testing to a blood test. Just pausing there. Is that an allegation of fact, or is it an opinion? Is it purporting to record what Mr. Telnikov has said, or is it merely the defendant's interpretation of it? Next paragraph. Mr. Telnikov is stressing his racialist recipe by claiming that no matter how high the standards and integrity of ethnically alien people Russian staff may be, they should be dismissed. Again, obviously, racialist recipe is opinion, but what are the words by claiming that no matter, etc., etc., was that an allegation of fact? And you can see that of ethnically alien is in quotation marks, which would tend to suggest it's something that's actually being said. And if you can then move on to page 352, page 69 of the bundle. This is the speech of Lord Keith of Kinkell. It was a 4-1 split, and Lord Keith gave the main judgment at A to D. Perhaps I could just ask you to read A to D.
Yeah.
And then Lord Acton was in the minority, but what he said is also relevant on this distinction between what the claimant said and the effect of the words. So he is at 363B to E, page 80 of the bundle. If I could just ask you to read that, please.
3638.
So B to E.
There we go.
So the obvious difference between Telnikov and the present case is that we have the claimant's words in the video. We can see what he said.
Yep.
And Guido has put in quotation marks the bits that were actually spoken. So it's only the freedom fighters that has the quotation marks around it. He obviously hasn't literally called Hamas freedom fighters in the video, as the viewer can easily see. Therefore, it has to be an interpretation. I mean, the issue on opinion is simple. As regards the freedom fighters meaning, it's, does the reader think this was said somewhere else in the interview? or does he think it's actually based on the words that you can see? And my learned friend said, oh, well, he probably said something else in the interview. I mean, that's just absolutely ludicrous. Guido Fawkes is going to put his best case forward. I mean, just apart from the fact that these are the words he's chosen, the claimants he's chosen to publish. It's obviously relating to those words. The ordinary reason really is not to think, oh, well, he hasn't literally called Hamas freedom fighters, therefore he must have said it somewhere else. He actually called them freedom fighters, but Guido didn't, in fact, decide to put that in the element of the video that he's showing. It was a ludicrous omission. And the judge applied Telnikov in the Bailey case, because in the Bailey case there was the freedom fighters' meaning. So I think it is, I mean, we may well be trespassing on, if I'm wrong, that we shouldn't even be looking at the Guido Fawkes tweet. It's perhaps worthwhile seeing how the judge addressed the freedom fighters' meaning in the context of Bailey for an idea of what he might have done if he had been asked to look at the Guido Fawkes tweet. Now that's in the unagreed bundle. It's tab 5, page 77. We should perhaps have a look at exactly what Lord Bailey said first. So if you, do you mind going back to page 73, paragraph 38. Right at the bottom, it's not very long. Can I just ask you to read the exchange that was broadcast on GBTV, which led to the claim against the...
Where are we?
It's page 73, my lord, paragraph 38. You can see straight away Lord Bailey goes in with, you've had major Labour Party donors who've called Hamas freedom fighters.
Yeah.
And the submissions, just two paragraphs of submissions, paragraph 58 on page 77 and paragraph 59. I just ask you to read those, please.
Yes.
And then the analysis follows, which, I mean, you perhaps read that if you don't mind. It's not that long, paragraph 61.
Yeah.
And then he refers to Telnikov as giving support to that conclusion. So if the judge was obliged to go beyond the RT tweet, the starting point would have been the GF tweet. And then he would have gone to the, if he went to the GF article, which he shouldn't have done because the hyperlink is insufficient, but if he went to the GF article, he goes to the GF article after he's made a determination on the GF tweet.
Yes.
None of these findings, it seems as if my learned friend simply wishes to incorporate the judge's finding on the GF article into the present claim. And then because the GF tweet, the video has the freedom fighters words in it, then we incorporate it also into the GF tweet. But, I mean, numerous reasons why that can't happen. one of which is that it's not, that's not the relevant determination in this case. If it were to be made, you'd have to start off with the GF tweet. So I was going to now formally move over to ground of appeal 2, although some of the submissions I have been making clearly relate to it. I believe that this is the first time that this court is being asked to consider the extent to which a judge is required to include in a meaning determination, or perhaps has the power to include in a meaning determination, a meaning not complained of by the claimant. It's an interesting issue. But however far such a power or duty can go, in my submission, it cannot go so far as to require the judge to include a discrete defamatory meaning in a part of the publication that the claimant has stated is not relying on for the purposes of meaning. It cannot go to this case. Judge cannot be said to be wrong, even within the extended Notting Hill meaning of wrong, not to have included the freedom fighter's meaning in his determination. The only way that the claimant can get the freedom fighter's meaning in is by an application for permission to amend, which should be refused, but as there's no application, we don't need to consider it. So I'm going to start by making my submissions at a relatively high level. So that's from the overview section of the skeleton argument. And then I'm going to move on to a detailed consideration of the details I can of the relevant authorities relating to pleading defamatory meanings of defamation, and also an appellate court allowing a new case to be raised on appeal. Start point is the meaning complained of in paragraph 14 of the particular claim, which is all relating to supporting Hamas. Ground of Appeal 2 says that the freedom fighter's meaning is a discrete meaning. So therefore it should have been pleaded. That's the first answer. It wasn't pleaded. The judge didn't have to make a determination on it. Secondly, there was an explicit representation. The claimant was not seeking to derive a meaning from the parts of the publication from which the freedom fighter's meaning could only arise, namely the video and the article. That's an answer to GOA 2. But then one has to ask, well, what is this? What is my learned friend asking the court to do? If it's an incorporation, there's three obvious additional problems. First, my client didn't make any submissions on the issue. Didn't have to. It's not a necessary response to the claimant's case. He'd have been willing to say that the reasonable reader would not even have accessed the article. The judge found that that was not necessary, as the claimant said he was only relying on it for reference. So my client cannot be bound by any determination in the Staines claim or the reasoning on which it's based. Secondly, the point that I made earlier, the route to getting to the Guido Fawkes article is different. There's been no determination on the GF tweet. And even if the judge was right on the GF article, and we don't think he was right, but it would have been a different conclusion going from the GF tweet to the GF article. So you can't just incorporate that meaning. There would have to be some submission, some argument either here or below as to whether the freedom fighter's meaning in the context of the tweet and the article is opinion or fact. Yes, and the third point is the judge's reasoning on the GF article, even if it is correct, doesn't necessarily apply to the GF tweet because of the difference in presentation. and the very heavy emphasis on the video.
Your submission, I think, is that the freedom fighters headline, I'll call it that, is an expression of opinion by Guido Fawkes, or if you like, an interpretation of that part of the interview which is embedded in the tweet.
Yes, obviously so.
Mr. Bennett says you can't have an opinion about an opinion as a matter of law,
No, that's
even if you could in real life.
especially what you mean by about. I mean, I would say these opinions are about the words used by the claimant. No, the first opinion is that their avowals are calling Hamas freedom fighters. And the second is my client's that this shows him to be pro-Hamas. I mean, the same argument was made in the Bailey case, because there was a further publication in Bailey where he was fundraising to defend for the libel claim, where he referred to the called Hamas freedom fighters. But then he said, we're trying to raise funds. There's also the important issue of standing up to those people who are apologists for vile anti-Semitic organisations like Hamas. So he got sued on the apologist meaning as well, which is quite similar to the pro or the support. And the judge again found that this was an opinion based on the words used in the interview. And in fact, Melania Friends sought permission to appeal on the basis, exactly the same basis. You couldn't have like an opinion on an opinion, or which was rejected by my Lord Justice Warby. It's a ludicrous submission. The only question is, does the opinion have a factual basis? Both opinions are based on the words used by the claimant. Which
There's a sort of ambiguity in perhaps in the judge's reference to what the basis is, because it could be, as it was in Blake and Fox, look at what has been said by Guido Fawkes,
yes.
or it could be, as you're saying, look at what Guido Fawkes has reported the claimant to have said, which is the underlying fact. I don't think we need to resolve that for this purpose. You made your case clear.
Yes, I don't think we need to resolve it, but with respect, it's the video, which is the claimant's own words. I mean, whether it's been tweeted by Guido Fawkes doesn't really matter. What the viewer is seeing immediately you get into my client's tweet is the words used by the claimant. So I would say that the analogy with Blake and Fox, which is the quote tweet is saying, see what this claimant has said, applies equally, even though the tweet isn't by Dale Vince, it's a tweet of his words. So it's like, look at what he has said 2 days after the 7th of October, when asked if a terrorist attack by Hamas is Palestine defending itself.
Yeah.
So those are the headline points. And I was going to now come on to my more detailed submissions, which start at paragraph 43 on page 61. It involves going through the chronology, then looking at the relevant legal principles, and then coming up with the obvious conclusion that this is has to be done by an application to amend and only by an application to amend. So Melania Friend says, well, this meaning is all wrapped up in freedom fighters' meaning doesn't have to be done seriously. The point was, same representation in 3 claims. In 2 of them, they've got a specific freedom fighters' meaning in them. Question arises, why not in this claim? I've given an answer. It's not been contradicted, and it's an answer obviously based on inference. But I would suggest that when you look at the meanings, I'll come to when I go to the transcript of the hearing. That's when I'll go to them specifically. But the other 2 both have a freedom fighters meaning there. And you've got to combine that with what was said to the judge. Frankly, Mr. Tice has done the damage with his tweet. That's what the judge was told. And Mr. Tice's tweet in that context was obviously the words used by my client. So we don't have the freedom fighters meaning. What we do have is 2 categories of readers. One who read the RT tweet and GF tweet, and another category who's gone on to read the GF article. And I suggest when you look at the particulars of claim, which I think I will come to now, it's quite clear that they're only being relied on for the purposes of reference. But even if it's not clear from the particulars of claim, which is the starting point, it is clear from what happens subsequently. But it is worth having a look at the particulars of the claim, which we can go to at Core Bundle 12, page 118, please. The last line of the page gives a reason for why they would have clicked on the GF tweet, then clicked on the hyperlink. They would have done so due to their curiosity in regard to what was said in the defendant tweet, because the means of reading the GF article was laid before them. Then refers to the GF article referred to the claimant by name. We have the meaning at 14 that you've seen. And then there's an extensive plea in relation to reference, starting at paragraph 17, goes on to various categories of information which would have been known. This is without even going to the GF article. And paragraph 23 on page 125. The reasonable reader who read the defendant's tweet would have followed the links from the defendant's tweet through to the GF article where the claimant was referred to by name. And then 23.2, they wouldn't have done, but they would have known who he was anyway. And then the reasons that are given why the reasonable reader would have read the defendant's tweet and the GF article. And this only becomes relevant if we come onto the respondent's notice, because if the claimant is allowed to derive a meaning from the GF article, there has to be a preliminary determination that it's actually part of the publication complained of. And that question is solely whether the notional reasonable reader would have clicked on the link. And interestingly, the 24.1, the first reason why they would have, I don't know how to mention it, on 24, the reason that it's relevant here is because it pleads, third line, where he or she would have learnt the claimant's name. That's what it's all about. And then 24.1, somewhat contrary to the submissions that were made in relation to ground of appeal 1, the purpose of a retweet is to draw attention to something tweeted by a third party. Where the person retweet adds their own comment, it will normally be obvious that the material referred to in the original tweet needs to be read in order to understand what the quote tweeter is talking about. Well, okay, but you can see what was in the Guido Fawkes tweet anyway. You can see the video. You don't need to go to the article for that. The reasonable reader will click on the link to the GF tweet because he or she was being invited to do so by reason of its inclusion in the defendant's tweet. In doing so, they would expect to be taken to the GF article by reason of seeing the hyperlink to it on the second line of the GF tweet. And just to be clear, there's 2 clicks. First to get to the GF tweet, second to get the hyperlink. 24.3, on being taken to the GF tweet, the reader would then have clicked on it in order to be taken to the GF article and therefore to discover what the defendant's statement, so major Labour donors pro-murderous anti-Semitic Hamas, was about. It's even tracking the words which he says have to be looked at in isolation for the purposes of GOA 1, is tracking it back right the way back to the article. But in any event, the reader knows what it's about from the video. He can see exactly what's being said. Doesn't have to go any further. It's self-contained, and Twitter's a fast-moving environment. So see clearly the GF article here is being relied on in relation to reference. Then when we got to the review hearing, where there's a dispute about whether this single publication point should be resolved, you've seen the paragraph from the skeleton argument, only relied on in relation to reference. There's a 46. Actually, I footnoted at footnote 4, there are numerous references to the GF article only being relied on in relation to reference. the 46 is not really very clear, but the judge then, it prompts the judge to ask specifically. So you're not, as I say, as it were, get anything further from the article and the video. It's the video, there's nothing else in the GF tweet with the freedom fighters meaning in it. It's just the box in the video. No, the reason why the article is important, not because of meaning. Frankly, Mr. Tice has done the damage with his tweet. For those readers who've read the tweet, who do not recognise Dale Vince, but still follow the link through and say, oh, look, it's Dale Vince who's been identified. And that's the point that damage is caused to Mr. Vince's reputation. We say that ought to form part of the case. Because as a matter of fact, that is what happened. It is not to do with meaning, it's purely a reference issue. And then correctly, turning over my page on my skeleton argument, Judge 86, Mr. Bennett does not seek any extended meaning from the Guido Fawkes tweet, the video clip, or the hyperlink to the full Guido Fawkes article. As he put it in argument, Mr. Tice had done the damage with his tweet. And do bear in mind that ground of appeal 2 refers to a discrete defamatory meaning. Called Hamas freedom fighters is a discrete defamatory meaning. So, as I said, starting point is it's not pleaded, therefore the judge can't be wrong not to make a determination in relation to it. And then on top of that, you've got specific representations that it's not being relied on. And on the back of that, the judge correctly found that it wasn't necessary to determine the single publication point. The stark contrast with Staines and Bailey. We can go to the transcript. Yes, so let's go to the meanings first, if I may. They're in the unagreed bundle. If we start with the Staines meaning, which is at tab 1, page 4.
So we're looking at this for what reason? Because this contrasts in a different case that was put differently.
Yes. While you're looking at this, I suggest that my starting point is the judge has clearly not done anything wrong by not determining the freedom fighters' meaning.
Yes.
The second, but the Maloney friend has raised the issue of Notting Hill finance, and to say that somehow it can be raised on appeal within the Notting Hill finance power. So what that does is require consideration of all the circumstances, and the starting point is an explanation as to why it wasn't raised below and why it's being raised now.
This is really reinforcing your point that what you've labelled the freedom fighters' meaning was not pleaded in the claim against your client, but we can see from paragraph 10 of the particulars of claim in the Staines case that it was pleaded against Mr. Staines and Guido Fawkes.
And there was a calculated decision which ties into the Del Olio case that was referred to by Lord Justice Warby in the Allen case, where you don't decide these things in a vacuum. The claimant's made a conscious decision. The first point is I'm saying that it would appear to the judge the claimant has made a conscious decision not to advance the freedom fighters' meaning.
Yeah.
Objectively speaking, whether to the judge or now even, that was a calculated decision. And there's no explanation. There must have been, there's been a change now. This discrete defamatory meaning has now, you're being asked to include it in the claim. Why? I say this is all purely tactical. There's no good reason. He knows he's going down on opinion. He's desperately trying to find a defamatory statement of fact somewhere. This is all purely tactical. There's the prudential assurance case, which my Lord Justice Lewison handed down the judgment of the court, which says if you're going to exercise this, you're asking the court to exercise this power to take a new point in appeal, you have to give a cogent explanation. There's no explanation. There's not even an acceptance that this is somehow different below. And some of my learned friend submissions was all wrapped up in the meaning of the support for Hamas meaning. Clearly, they didn't think that it was all wrapped up in the support for Hamas meaning because they, on the other cases, they've chosen to include it. So I'm asking you, if necessary, to infer that that was a tactical decision at that time not to include the freedom fighters' meaning in the present claim. And it's a tactical decision to try and get it in now. All to be seen in the context of the judge being told, frankly, Mr. Tice has done the damage with his tweet. Completely different volte-face now. Oh no, it's really important for us to complain about the Guido Fawkes article and the freedom fighters' meaning. In fact, well, the claimant's not even saying it's really important to him. There's no explanation at all. So I think in those circumstances, it is relevant. Two reasons. For the judge to think he doesn't have to include the freedom fighters' meaning because it's being actively asked for in the other claims and it's being told, no, you don't have to look beyond the tweet in the Tice claim. And also in terms of explanations for decision making and why it's being raised now if it's a new point on appeal.
And the underlying point is that the freedom fighters' meaning can only derive from the headline in the GF tweet.
Yes, or the article.
Yeah, or the article.
Which, my friend told the judge he wasn't getting anything further from the video. So when I say the headline, to be clear, it's in the video. It's not. It's part of the video. It's not a headline as such. So it's very important to have the elements of the publication.
Well,
in mind.
is that right? Mr. Vince in the video doesn't explicitly call Hamas freedom fighters. It's an inference that one might draw from 3 or 4 sentences that he said. Having said one man's freedom terrorist is another man's freedom fighter, that's a fairly unexceptional statement. It's when it's applied to Hamas that it might become different, because he then says that he puts in that it's not Labour Party policy. I can't remember the exact words, and he says, "Well, that's how I feel." I mean, it's the combination.
I'm making a slightly different point, which is that the video has something on the left-hand side, which is a box,
Yes.
and the called Hamas freedom fighters is within the box.
In the box, yes.
So it's within the video. The video is within the tweet, but the freedom fighters' words are within the video. We can go to the supplemental bundle.
Words of the tweet itself were quite limited.
Yes. So it's page 3 of the supplementary bundle.
Page 3 of the
Supplementary bundle. So the multi-million-pound donor to the Labour Party says Hamas are speech marks freedom fighters. That is within the video. It's non-moving, but it's in the video.
Right.
The actual words in the tweet are, while we're on the subject of extremist donors and returning their donations.
Yeah.
Can I? It's maybe a dumb question. There's a link, or there's an address, order.com.
Yes.
What's that take you to?
That's the GF article.
That's the article.
Yeah, but you can't get to it from the RT tweet because there's not. I don't think there's enough of it there. Or you've got to get into the.
I thought you'd said earlier that link, or someone had said earlier that link wasn't visible in the tweet on the page, but that's the link to the article.
It's partly visible. Yeah.
Right, Mr. Price, is that a convenient
Yes.
moment to stop? 2 o'clock.
Court rise and able.